Welcome back to Good Law, Bad Law. When is it okay to discriminate against somebody based on their health status? Maybe they're a smoker. Maybe they are obese. Maybe they have a medical condition. Are there circumstances where it's actually okay to discriminate against such a person in the workplace or in some other way? My guest on today's episode is Elizabeth Weeks. She is a professor of law at the University of Georgia Law School and the co-author of a new book called Healthism, Health Status Discrimination in the Law. And we have a really great conversation back and forth on this topic, something that affects people in the workplace, what types of behaviors might be taxed, like drinking a big gulp, for example, or using a tanning bed, as a famous reality star was famous for doing, and maybe a president or two here and there. You're going to want to understand this issue, and it's a really great conversation with Professor Weeks on Healthism. Stay tuned. Welcome back to Good Law, Bad Law. On today's episode, we're going to be talking with a professor of law whose specialty is in the area of health law in particular. And we're going to be talking about something called Healthism. And the question we want to address is, when is it okay and when is it not okay to discriminate against somebody on the basis of their health status, which I think is a really fascinating question right off the bat, because we think that it's never okay to discriminate. But Elizabeth Weeks, the author of a new book called Healthism, Health Status, Discrimination, and the Law, is with us to help us through this. Elizabeth, thank you very much for being on the podcast.
Thanks so much for having me. It's a pleasure.
I read most of the book over the weekend and over the last couple of days. And boy, this is a fascinating and challenging issue, challenging in the sense that, as I say, I think most of us assume that discrimination is always bad, but there actually are circumstances when it comes to health status, and we need to go through some examples, I think, to understand this, where actually it is okay to discriminate.
Yeah, exactly. I mean, I think that's been one of the real challenges with this project, is trying to think about the sort of, I think our gut or our visceral reaction is to think, well, yeah, discrimination is bad and people shouldn't be treated differently just because they're unhealthy. And certainly that's our how we tend to approach other protected categories that are legally recognized, such as race and ethnicity and gender and various other statuses. I mean, there are very few, if any, instances in which we think it's permissible and maybe even a good thing to treat somebody differently based on race or gender. There are limited exceptions. For example, in employment law, there's a BFOQ, or bona fide occupational qualification, where if the example I remember from law school is if a director of a play or a movie is casting for Roots, they may audition only African-American actors. So that would be a rare exception. The challenge with thinking about discrimination based on health or the status of being unhealthy as a protected class is there actually are a number of instances in which differential treatment based on health is not only permissible, but may actually be beneficial for that individual as well as for society at large.
Well, and as I say, we'll get into some of the different ways that we look at that, some of the different variables to consider, and some specific examples that will help illustrate all this. But first, I'd like to get some background on you. I looked at your bio, and I see that you went to my alma mater for your undergrad. You went to Columbia, and you went to my wife's alma mater for law school. You and now teach at the University of Georgia. So you were a bulldog. So we have to say, go Dogs.
Go dogs, exactly. Along with a little bit of roar, lion, roar.
Right.
Exactly. Right. Yeah. So actually, I'm an Athens native. I'm a townie who has managed to find her way back home after a few other twists and turns. I actually, after Columbia, I lived in Chicago for 3 years and was a psychiatric social worker at a community mental health agency on the far north side. And then I went to law school with the actually, I applied to social work school as well, and it was all about, I'm going to fix the system. I've been in the trenches. I've been doing direct service work, and I need to be a better advocate. And law school ended up seeming like the right path for doing that. As it turned out, I loved the study of law as an intellectual exercise far more than I expected to, and I was fortunate to be able to clerk and have some other great career opportunities after law school, including I practiced with a multinational firm in Houston in their health industry group. So I kind of switched sides from working with beneficiaries of Medicare and Medicaid when I was in Chicago to working with institutional healthcare providers that were reimbursed by Medicare and Medicaid and other payors when I was in practice. But I loved that, the deep regulatory questions and the challenges of that practice. And then eventually, actually sooner than I might have anticipated, I ended up with the opportunity to enter the legal academy and have been teaching for 16 or so years now.
So how, Elizabeth, how did you come to this book? I mean, you've been in the health industry as a practitioner, on both sides, as you told us, and practicing in the area of health law with the firm in Texas. And I know that this is a special area of interest to you in your academic life. But how did you come to this book in particular? Because you really are setting out, I think, in this book to not only discuss but to define these issues. And so I take it that you must have felt that that was something that we needed, that there wasn't really good working definitions of what is healthism and how does that play out in different
absolutely
ways?
I mean, certainly the goal of the book is what you just said, is to really to put this concept into the public lexicon and to create a conversation and a dialogue around it and to identify instances of healthism that are already at play and to think about whether legal solutions are needed to address those. The genesis of the project, though, really came from sort of a more core area of my research interest, which is healthcare financing and regulation. I do a lot on Medicare and Medicaid, as I mentioned, but also on commercial private insurance, and particularly around the time of the debates leading up to and culminating in the enactment of the Patient Protection and Affordable Care Act of 2010, or what we still sometimes refer to as Obamacare. There was a welling up of public sentiment, and which eventually was codified in the law, that denying people health insurance and charging people different rates for health insurance because of their health status just wasn't the right thing to do. Even though historically and from an insurer's perspective, that's absolutely the right thing to do. We don't sell car insurance to everyone at the same rate. We don't have community-rated car insurance. We don't sell flood insurance to somebody in a floodplain without significant government subsidies. And so historically, the same had been true with health insurance, is that your individual risk profile very much was relevant to the insurer's decision whether to underwrite you at all, and if they did, on how much to charge you for premiums. And granted, there had been some state laws addressing those kinds of practices, but the Affordable Care Act represented at a nationwide level a public policy shift that approach to health insurance no longer was permissible, and that really was the core of our thinking about this project. I have a co-author on the project who's actually coincidentally at University of Houston, not somebody I knew when I was practicing there, but
right,
exactly,
that's Jessica
Roberts. And Jessica had actually written a couple of articles, one on healthism and health insurance, this issue that I've just been describing, and then a separate one on healthism in the workplace, essentially. And her examples in the workplace were looking at some practices that were becoming more common among employers that are sometimes called lifestyle discrimination, where an employer refuses to hire workers based on out-of-work conduct. One of example of which might be the worker uses tobacco at home, or the worker is obese. And again, not necessarily conditions that have anything to do with how the worker engages on the job, but simply are bases on which the employer might nevertheless refuse to hire that individual.
But those are two. I mean, those are two interesting examples to start with, and I know we'll get into this more later. But those are two very different kinds of situations, because in the tobacco example, somebody could smoke or use tobacco in some other way at home, but not in the workplace. But you can't be obese at home and not be obese at work. You either are or you aren't.
True.
So that's something. I mean, you can talk about how does a person get to be obese, but if a person is, that is who they are, and that is how they are, regardless of where they are at one moment or next. So those would play out very differently in the workplace.
They would, except that if the nature of the job is such that being obese doesn't change the person's ability to perform the necessary job functions, then it really isn't any different from the fact that the person uses tobacco at home. And I have colleagues who've done much deeper work on ADA issues and obesity, but essentially the ADA applies only to people who are considered morbidly obese. So there's a whole cohort of individuals who fall outside of disability protection based on their weight status, and thus that's that group of folks that we identify who are not currently protected against discrimination.
All right. Well, so I understand. So let's spend another minute or so on this, on the Affordable Care Act, because you describe that as representing a policy and societal shift in thinking about health and how it relates to insurance. And that is a big driver of policies that may end up in discriminating against somebody because of their health. The tobacco example, again, is a good example of that. As an employer, I know this. As an employer who provides health insurance to my employees, I know that the cost of insurance for an employee who is a smoker is higher. And as an employer, if I'm paying that cost, I'm paying more for the choices that particular employee makes in terms of smoking. So what is the shift that, tell us again what the shift is that the Affordable Care Act represents? An idea that certainly we want to increase access to healthcare if we believe fundamentally that healthcare is a right. So how would you describe that shift then?
Yeah, I mean, I think you're absolutely identifying the right sort of dichotomy, and I wouldn't go so far as to say that we've identified healthcare as a right in the United States. We've been pretty firm on that. Our Constitution protects rights in terms of things that the government can't do to us or can't impose upon us or can't take from us, but it doesn't impose affirmative rights, things that the government is obligated to provide to us. And so I think, there's certainly some rhetoric around the notion that the Affordable Care Act represents some kind of right to health care, that the essential health benefits package is a right. But accepting that we're not quite there yet in terms of our policies and laws, I do think that the Affordable Care Act represents a fundamental shift in thinking about the purpose of insurance. Classic notions of insurance are financial protection against catastrophic risk. And health insurance has become not that, but rather a way to finance routine and regular and preventive health care for very good reasons in terms of reducing overall health care costs and improving an individual's health. And moreover, I think the Affordable Care Act and laws that embody similar policies envision health care not as something that's an individual protection against financial catastrophe or exposure, but rather a sort of a way of collectively pooling resources to ensure that more people have health care. So it quite clearly affects a form of cross-subsidization that has not been as transparent in previous laws. So in your workplace examples, certainly if you have employees who are obese or who use tobacco, there's a pretty good statistical evidence to suggest that those people will have higher healthcare costs and perhaps greater absenteeism or lower productivity because of their health conditions. And so, yes, as an employer, it certainly seems rational that you would care about those risks and would want to take steps either to have them pay more, representing the additional costs that they will bring to your business, or to create some sort of incentives within your healthcare plan that would encourage them to adopt healthier lifestyles. I check a box on my open enrollment that says I'm not a tobacco user, and I get a $15 discount or whatever it is on my premiums. But I think that the notion of charging everyone the same for health insurance, irrespective of his or her individual risk profile, just represents this broader notion of insurance as a way of extending health care access to more people. And again, quite clearly by requiring some people who, under a risk-based rating system, would pay less, they're going to end up paying more because they're subsidizing the cost of others.
Well, right. In a way, it's become upside down, I think, in a lot of ways. Healthy people and pools of healthy people pay more relative to their risk profile because insurance companies have to cover the costs of those who have higher risk profiles and are gonna cost the insurance company more. So if we're looking at where is their fairness or where is their discrimination and unfairness in regard to health status, in some ways you could argue, given the way insurance is priced today, healthy people are the ones discriminated against, not the unhealthy.
No, I think you certainly can, and certainly people do argue that, right? And that's, I think we will see. I was thinking as I was thinking about this call with you yesterday, I was teaching in my regular health law survey class with my students yesterday the individual market reforms under the Affordable Care Act. And of course, as of January 1, 2019, there no longer is a tax penalty associated with the individual mandate part of the Affordable Care Act. So that throws the whole question back up into the air, where there certainly are all the Obamacare exchange plans that have all the requirements that are under the Affordable Care Act. But there's also this whole other market of insurance products out there, short-term coverage, catastrophic coverage, association health plans that don't have these rating requirements or pre-existing condition bans or essential health benefits packages. So we're back to very much inviting a host of discriminatory practices within health insurance. And, the counter argument to that is, well, yes, but we're also allowing a great deal more of diversity and individual choices about the type of policy that people want to be covered by and how much they want to pay for it. So this whole promise of the Affordable Care Act operating as something of an anti-discrimination law for the unhealthy, I think, is very much in question in the current climate.
Mm-hmm. All right. Well, let's get into the meat of healthism, which is the subject you've taken on in this book. And we started out, identifying the idea of discrimination as something that may be okay and may certainly not be okay in other situations. We all discriminate all the time in so many ways. We may not use that word to describe it, but we choose friends. We choose where to sit on the bus. We choose what to order from a menu. We're discriminating in our choices all the time. But what you're looking to identify here is when and under what conditions can a person's health status be a basis for unlawful or unjust discrimination. So how do you start out even approaching that huge question?
Yeah, no, that's absolutely the huge question, and I think the hardest question in the book. Again, accepting our baseline, which is that this isn't an obvious no, or it's not an always no to treat individuals differently based on their health status, right? So what we ultimately do at the end of the book, and we do this by walking through some kind of theoretical guideposts and a host of other examples, is give sort of a decisional rubric to readers at the end of the book, which is not a neat and tidy test. It's not an easy elevator pitch, but it's sort of it's a list of factors that point to, on the one hand, health status classification, because as you say, we all make classification decisions all the time. Health status classifications that we think are what we say are normatively wrong, that we think that should not be supported or condoned by the law. And then another category of health status classifications that we think actually are permissible or even desirable. So it's this sort of messy, multifactorial test that we offer, or a test maybe is too strong of a word, a list of considerations. And, you know, we worked on this and tried to think about different ways to approach this, and this central question of how to draw that line between the permissible examples and the impermissible examples is really, really tough. And I think by ending up with this rubric is really the most accurate, given the heterogeneity of examples that we explore, the various contexts in which people may be treated differently based on their health status. We've talked about the workplace and we've talked about insurance, but there are a host of other examples in just in everyday life. One example we talk about in the book is whether airlines can charge a passenger who's obese for 2 seats if he is sitting in more than one seat, or if a family, a couple decides to get testing before conceiving a child, and based on those results of that test makes a decision not to carry the pregnancy. Is that healthism? Is that something that we want people not to be able to do? We find that impermissible. So these examples are really, really different. And so to try to come up with some kind of pat answer or single approach to dividing that line just didn't seem accurate to the landscape.
Well, and you're using the word healthism to, I gather, to refer to whatever we would decide or what the law would decide is impermissible discrimination based on health status, right?
Exactly.
And obviously that's drawing on the language we use to describe other kinds of impermissible discrimination, racism being, discrimination obviously on the basis of race, and sexism on the basis of sex or gender, and so on. But in those historically well understood kinds of discrimination, race, sex, religion, now sexual orientation, which is sort of, for some people more challenging because race is not something a person chooses. That is their race. That's their skin color, or that's their ethnic background. Obviously, gender is maybe different from sex, but even there are ways in which notions of what is the class of people we're even talking about to understand whether the discrimination is accepted or not. But when it comes to health, we're really opening wide, it seems to me, this notion, because and maybe we need to start in with some of these different variables. I mean, yes, you can't change your skin color, but there are certain things that we do choose when it comes to our health, right? If you're obese because of a DNA issue or genetic issue, that's one thing. But if you're obese because you've made decisions about diet, exercise, and what have you, that seems to be something different. But on the other hand, if you come from a low-income neighborhood and you don't have access to healthy foods in the way you do in a more affluent neighborhood, what does that do to the equation?
Right,
And the whole
exactly.
issue of whether you're really choosing or not. So I mean, that just seems to raise a lot of challenges but maybe you could speak to that a bit.
No, I mean,
the issue of behaviors and choice.
Absolutely. I mean, you're absolutely right that there are, I mean, as much as even conditions that we think are immutable and are just in our DNA. I mean, there's certainly good scientific evidence that there's an individual behavior or a host of other components that go into those health conditions and how they end up manifesting in any individual. So that is certainly a challenge. And I guess for that reason, when we define health status for purposes of this project, we are not limiting that definition to diagnosed, identifiable, immutable conditions, because it's just not realistic to say that that's a way to describe what it means to be healthy or unhealthy. That creates challenges for the project, but it's not outside the realm of existing anti-discrimination work, scholarship, or laws. Certainly, your examples with respect to gender identity is one possible example, but religion. We have laws that protect people against discrimination based on religion or based on military service background or based on pregnancy. And those are situations in which there is also a choice about whether to acquire that status. And there's been some very good scholarship on this. One of the articles that we worked with in thinking through these issues is by Jessica Clark in the Yale Law Journal on against immutability. So this whole notion of trying to limit anti-discrimination law just to immutable conditions. There's been work on that supports our thinking about it. But I think it does present additional challenges in thinking about health status because, as you suggest, and as we've talked about with some of the other examples, it's one thing to say there shouldn't be discrimination against somebody who has cancer. It's another thing to say there shouldn't be discrimination against somebody who uses tobacco. That one seems like a voluntary choice, and another seems like simply a condition that person is now burdened with. The rubric that I referred to earlier, I think, helps think through those issues. And again, I think that's part of the reason for the fairly complex approach to the dividing line. So we do consider things such as you referred to, social or health justice issues, where if a particular law or policy tends to punish somebody for individual choices over which they may not have full control because of various social and economic circumstances, that would tend to counsel against finding that example to be healthist. If there are other laws or policies that tend to incentivize someone to engage in healthier behavior and there don't seem to be any extenuating limits on that person's ability to make that autonomous choice, then that would tend to counsel in favor of that law or policy being perhaps a health status classification, but one that is not healthy.
Okay, so but you covered several different kinds of laws or regulations that might be thought of by the person they impact as being discriminatory. So you mentioned when we've talked about this in an employment context, for instance, so an employer in some circumstances can make a decision affecting the employment of an individual based on their health status in some cases, but not in other cases, right? And I want to come back to that, maybe ask you to help us understand something about when we can and can't. But also you mentioned a law that could look to penalize or tax somebody because of a health status. And I even made a note of this in reading the book that I wanted to ask you, and maybe this will be a good example of this, the Snooki tax. So maybe we can come back to that too. But then there are other kinds of policies or regulations, maybe even taxes, that could be used to encourage healthier behaviors, which is a whole different kind of discriminating conduct in terms of law, and maybe we have to talk about that too, especially as there are more and more political candidates now talking about healthcare access for all, or Medicare for all, and what that might involve if we're going to have the government insuring everybody. Is the government then going to be able to, have a greater role in promoting or penalizing certain behaviors in terms of health? So that's a lot. I just threw out a lot of stuff there, but I was picking up on some of the things that you had said. So maybe can we start with the employment case, because we've touched on it, but give us some, if you want to apply this rubric and this notion of healthism, how do we understand, and I know you could probably teach a whole course just on this question, but how do we understand some of the considerations, let's say, in when health status could be fairly a part of an employer's decision and when it could be not so?
Right. So, all right. So maybe, I don't know if it's helpful. I can kind of tick through the rubric, and we have a framework for talking about it. So it's in Chapter 6, Table 6.1 in the book. And so we have characteristics of socially desirable health status differentiation. So these are socially desirable situations in which people are treated differently based on their health status. If the law, policy, or practice tends to promote healthy decision-making, facilitates individual choices regarding health, lowers health risks or lowers healthcare costs, and facilitates better healthcare and better healthcare access. Characteristics of healthist or socially undesirable health status classification: if the law, policy, or practice is driven by animus, stigmatizes individuals unfairly, punishes people for their private conduct, impedes access to health care, cuts off resources, or otherwise limits the ability to adopt healthy life choices, produces worse health outcomes, or maintains or increases existing health disparities. So again, not a tidy elevator speech, but a fairly nuanced and inclusive rubric. And to get to that rubric, we develop earlier in the book some theoretical guideposts that I referred to earlier, and those involve health welfare, sort of notions of general individual as well as societal welfare. Notions of equality, of course, are very much bound up in any discussion about discrimination. Health justice, which is a more recently developed concept having to do with some of the issues you raised as far as social or other barriers to accessing healthier life choices. And those theoretical themes come through in this rubric that I just read through. So an example which we give, and again in the last chapter, as we apply that rubric to some of the examples raised earlier in the book, and give an example of, here's what we think is a pretty easy case for healthism, here's what we think is a pretty easy case of health status classification that's not healthist, and here are some cases that we think are in the middle, meaning that they need maybe some further development on the ground, as well as on sort of the empirics of what sort of health outcomes might be produced by applying that particular law, policy, or practice. So can you give us an example of each? The easy case of healthism, the easy case of or easy to see case of permissible differentiation based on health status, and then an example of something that's really in that gray zone. Right, sure. So the easy case of a healthist policy or practice, we think, would be the nicotine hiring ban. Mm-hmm. So again, this is a situation in which, drawing on those guiding principles, smoking is something that creates a negative welfare effect for both the individual as well as for others. So you would think at first blush this seems like beneficial. This seems like a good thing, that this might be beneficial for both the individual and society. However, because it turns on activity that is out of the workplace, and again, stipulating that it doesn't affect the person's ability to perform the essential job functions, it's really not a fair basis on which to draw that distinction or to deny that individual access to a job and therefore, in most cases, access to health insurance. So therefore, it would undermine that person's ability to obtain treatment or to obtain smoking cessation resources by limiting their access to both employment and to employer-based health insurance. We also discuss with that example how animus against tobacco users is quite strong, and it seems to be that is one of the motivating factors behind that particular law, and the singling out of tobacco users, which is, it's true also in the Affordable Care Act. There's even under the community rating provisions of the Affordable Care Act, there's an exception based on age as well as on tobacco use that insurers can charge higher to tobacco users. And so this, there's a pretty strong history of singling out tobacco users as a particular group of people engaged in an unhealthy or perceived to be unhealthy habit. So that would be one of our examples of a clear case of health status discrimination that falls into the healthist category.
Well, and even with that, though, I mean, just to show how nuanced this can get, even in that example, I can think of all kinds of other issues relating to it that could complicate it. I mean, is there a difference between someone who smokes 2 cigarettes a day or only when they, go out to Friday happy hour, and someone who smokes a pack a day? I mean, I think, yeah, there probably is. If somebody says, I don't smoke during the day, that eliminates an employer's potential concern about taking breaks, because nobody smokes in the office anymore. You have to go to, outside or to some place where you can smoke, and that leads to more breaks, theoretically. But if someone says, well, I only smoke at home or not, so it's not even that universal. And I was also thinking about that example this morning. The science changes too.
Exactly.
Obviously, I mean, we've seen that. So there's so many developments, in understanding the genome. I don't even think too science fiction-y to imagine that someday somebody could understand their DNA well enough to say, well, we know that cigarette smoking doesn't cause cancer in everyone who smokes. It's that it's a statistically significant increase of risk of that happening. But I know I've looked into my DNA, and here's a report saying I'm not one of those people who's at high risk for developing cancer from my smoking.
Yeah, that's right.
In other words, the science could really evolve in a way that challenges a lot of these things.
Exactly, right. And that's another piece of it. That's some of the examples that fall into the close cases or the middle ground are precisely for that reason, because there's needs to be further scientific or empirical development to draw the conclusion in terms of health welfare. Is this a policy that actually does improve either this individual's health or societal health in the aggregate? And that, again, being just one of the considerations, not the sole consideration, but absolutely that complicates the picture. And, it's, as I said, I think the fluidity of this rubric is dissatisfying. It's certainly dissatisfying to me as an author, and I think it's one of the hardest parts of the book, I imagine, for readers. But again, we just, it seems like the most workable approach given, again, the landscape. And, one analogy that we have suggested to sort of appease or maybe shed some light on that discomfort is another area that I teach is first-year tort law. So in tort law and negligence, the standard by which we determine if somebody is held liable is this reasonable care standard. And we spend, months on defining what reasonable care means, and it's
good luck.
Right, and it's fluid, and it turns on the circumstances, and it changes with time. What we think is reasonable or ordinary in an objective sense is different from case to case and from time to time. And so in some ways, our approach is not dissimilar from that because it does ebb and flow and accommodate these various situations. But for all the same reasons that my students, pull their hair out over reasonable care, there's going to be some of that necessarily with this approach as well.
Well, I practice tort law, so I pull my hair out every day on those
Right.
issues.
Right.
But as you say, I mean, you're not this rubric and these considerations not only aren't but can't be said in concrete. You want to start a conversation and have this be a basis for further discussion and exploring this. Okay, so what's an example of out and out healthism that doesn't meet any of the positive characteristics of what you call desirable health status differentiation and ticks a number of the negative boxes that are evidence of improper, impermissible discrimination?
Yeah, well, I guess that's the one we just did, right? So the workplace hiring ban, we find that falls into the healthist category pretty cleanly. But counter, yeah. So, but a counter example, and to your point about these are fine-tuned distinctions, and that is one of the examples we use as far as benign health status classifications in the book is also addresses tobacco, but addresses it in a very different way, which is instead of refusing to hire a worker because he or she may use tobacco out of the workplace, which again denies access to the job and to employer-based insurance and perpetuates existing stigma and stereotypes and operates out of some sort of deep-seated negative views of people who use tobacco. On the other hand, we would consider a situation of a workplace wellness program, like a tobacco cessation program, to be not healthist. Although it does treat employees differently, smokers or tobacco users versus non-tobacco users, we would not find that sort of policy that merely creates incentives for an employee to participate in a particular smoking cessation program. We would not find that to be healthist. It promotes that individual's autonomous choices while giving a little bit of a nudge to do so. It doesn't limit his or her access to other healthcare resources. In fact, it extends his or her access to smoking cessation programs, assuming that the participation doesn't require the worker to get child care or overcome other transportation challenges that may impede participation in something like a fitness program that requires going to a gym or something like that. If the participation can be done with support of work time and work hours, then we would find that to be a health status classification that is non-healthist.
Well, and then, of course, there's a difference between offering that benefit, say, a discount to a smoke cessation program or to a fitness center, and requiring it. There's a big difference.
Exactly. Absolutely. If it's required, then we lose the health liberty piece, right, where then we don't have individuals making autonomous choices.
Okay, so I thought this first example you gave was an example of permissible discrimination. So that shows you, the ways different people could see the same situation from a different perspective. Because I would have thought an employer has a rational basis for that classification, or could anyway.
Absolutely. No, absolutely an employer could. Just as we said an insurer absolutely could have a rational basis for charging me more for my health insurance based on my individual risk.
But you could also see how those types of decisions, and I think it's easy to imagine these playing out in the workplace, so it's great. It's a good way to illustrate these. You could see how, okay, maybe tobacco feels more comfortable because I don't think there's a rational person alive who can dispute anymore that cigarette smoking and tobacco is terrible for your health and causes all kinds of health problems, from heart disease to lung cancer and so on. But there are other things that once you start down that...
Your example of the person with the special DNA.
Well, right. Leaving that blessed person aside.
Right. Right.
then you do step out onto that slippery slope. I mean, you talk about this example too, that there are many health professionals today who would say you should drink 8 glasses of water a day for optimal health. Well, could an employer require employees to drink 8 glasses of water a day, or could an employer decide not to hire someone who refuses to commit to
Who
that
doesn't drink?
goal? Because that
Yeah.
would be evidence of unhealthiness, and therefore, what, higher insurance costs, greater absenteeism, other things that an employer would legitimately be concerned about. But I think we all look at that and say, "Come on, that seems silly," but that could be where we're going with this.
Yeah, no, I mean, I think that's right. And I think that's again, one of the real challenges with the project. And just kind of by way of backstory, part of how I got involved in this project is thinking of those kinds of counter arguments. So again, Jessica Roberts had been writing about these issues, and particularly in the health insurance context, which is kind of my bailiwick, just putting forward sort of as a normative assertion that, of course, this is a bad thing. Of course, people shouldn't be denied access to health insurance or shouldn't have to pay more for their health insurance because they're unhealthy. And I think there's a lot of intuitive appeal to that, and that certainly, again, was, I think, part of the rallying cry behind the Affordable Care Act, is that we can't deny health insurance to the people who need it, who need health care the most, that is, the unhealthy. And my response in reading Jessica's articles was like, well, but wait, there are good reasons why, very rationally from an insurer's perspective, they're not going to, that's not an insurable risk, right? The person who already has cancer is not an insurable risk. That's just a known cost. So I think those concerns and those, that's certainly true. And we're not going to argue that there are not rational business reasons to treat people differently based on their health status. But rather what we argue is that in order to consider whether such treatment is permissible, we need to think about these broader social goals. And again, the book lays out the themes of health welfare and health liberty and health equality and health justice. And those animating values are what feed into the rubric and help us make this determination. So it's not a single set of factors, and again, certainly lots of room for differences of opinion. And again, ultimately, our goal is to be provocative and to open these conversations, and not necessarily to say that our example and our conclusion on the particular example is the be all and end all.
Well, we've talked about employment. We've talked about health insurance. Let's say a few words, because I did introduce this idea earlier. Just say a few words about the role of tax as a means to promoting greater health. And if you look at your rubric, this is, for those who get the book, on page 181 of the book, taxes aimed at promoting better health do seem to fit into, do seem to tick a number of the boxes in terms of what would be desirable differentiation. And I'll give you a couple examples maybe to jump off on that issue. You mentioned the Snooki tax earlier. You can tell us what that was, but also what probably even more people have heard of is the soda tax that passed in New York, and actually in Philadelphia, where I am, has been in place, I think, for a couple of years now, and many people think it's working pretty well. So what do you think? How do those types of regulations fit into into the rubric?
Yeah, so we take up those examples early in the book when we're trying to talk through some of these organizing themes, and the point that we make at that juncture of the book is to recognize that there are certain policies like that are paternalistic in a sense. They are intruding on people's autonomous choices through these nudges, to use the Cass Sunstein notion, that we think that to the extent that Snooki tax, which is this was one of the Affordable Care Act provisions, an indoor tanning tax after reality star Snooki is kind of how it got dubbed, and banning large portion sodas. Those are relatively soft forms of paternalism that
The big gulp tax.
Yeah, the big gulp tax that encourage healthier choices, but do not outright prohibit unhealthy ones. So there is some still a degree of autonomy within those practices. And again, that part of our discussion deals with just this one guiding principle, that sort of a health welfare notion and a health liberty notion. But the decision about whether those examples would be healthist or not would need to take into account some of these other values. So to the extent that if the big gulp ban is born out of some deep-seated stigma or stereotype against the obese and tends to perpetuate those disparities and that stigma, then it could tip in onto the side of a healthist policy. However, if it is if it's an example, I don't think there's perhaps the same sort of stigma against people who use indoor tanning beds. So that might.
If there is, it's well-founded.
Yeah, exactly. Our president, and controversy around that question aside, so I think that absent that sort of deeper historical or societal stigma or stereotyping, that might counsel in the other direction. But again, it's this sort of multifactorial approach.
Well, okay, so I want to wrap up with just throwing something completely way beyond the amount of time we have left to talk about, but something I'm thinking about, which again is we now enter the long political season towards the next big national election. There does seem to be coming into the mainstream, or more into the mainstream anyway, from way out in the fringe of progressive politics, this idea of Medicare for all. And I don't want to necessarily get into a whole debate about, whether this is leading us to socialism or, the role of the government in implementing plans, better or worse than the private sector necessarily. But I'm interested from the healthism standpoint, because clearly you're separating out, at least for consideration as a more positive kind of health status differentiation, even though you might use terms like Big Brother or have concerns about privacy and things of that nature. Policies, whether they're regulations or laws or taxes that promote better health and reward better health choices, those we should see as a good thing. So if Medicare is for all, does that create opportunities for through the government, greater opportunities either for good or for mischief when it comes to some of these things that we've been talking about?
Yeah, no, it's a great question. And I think there, as we've already identified in this whole landscape, I think there are a lot of different moving parts. I guess on one point, it strikes me that on the question of sort of health insurance issuance and pricing, a Medicare for all approach would not involve that. Again, existing Medicare is available. There are some premium variations based on means at the high end and at the low end, but by and large, it's a uniform program for people. We don't exclude people based on pre-existing conditions. We don't charge more based on individual health status factors for Medicare. So to the extent that model would be extended into a Medicare for all plan, I think that would be consistent with the concerns that we identify behind healthism. However, as you suggested, within a government-provided national health system to include various incentives for healthier behavior, for better decision making around accessing preventive health or accessing healthcare early, or using various resources. I think those all would be appropriate and consistent with the positive examples of health status differentiation that we outline. And I think, it reminds me, I've written in other places on sort of questions of rationing in healthcare and all the alarm that came up around, again, in the 2009 debates, and Sarah Palin's Facebook quote about the death panels and all that. I mean, there's a great deal of fear in the public's mind about this notion of rationing healthcare or making cost-based decisions on how to extend healthcare to individuals. And, no matter how we deliver healthcare, whether it's through our existing sort of hybrid of, we have some people who qualify for government benefits and other people who are on the market and some people who are subsidized on the market, or if we have a universal healthcare system, we're still in a world of limited resources, and we're still in a world where we need to make good choices about how to use those resources. And if part of that calculus includes encouraging individuals to make good choices and to engage in healthier conduct, I think that's permissible, and I think that would be a positive use of health status classifications. However, as we've already talked about, I think the devil is in the details, because I think we'd really have to consider whether a particular element of a Medicare for All policy would cross the line into something that we would think is healthist and should give us pause before implementing. We really, would need to unpack it more specifically.
Well, and you say there's a lot of fear, that enters into these discussions, and there's also a lot of money that enters into these discussions.
Absolutely.
My wife and I just watched In Defense of Food, Michael Pollan's special. And, he's pretty credible authority on these things and talks about how much money and industry and lobbying is behind a lot of what we're fed about what is good for us to eat and not good for us to eat. And so, you kind of have to know a little something about who's talking when they're talking to you about what is health and what health status we should even be considering.
Exactly. Back to the 8 glasses of water a day and that kind of thing. Exactly.
Eat real food sounds really good, but you can also see that the packaged food industry really doesn't have an interest in that philosophy.
And I think that's right. And I think, again, part of the challenge in defining this is because necessarily part of our definition of sort of the good examples versus the bad examples is the good examples are the ones that tend to promote individual health and societal health. And again, that being just one of the considerations. But whether that's true or not turns on the science, right? And that science is going to evolve.
Well, this is a great start. The book, if anybody is interested, and I think everyone should be interested in this topic, this has been a fascinating introduction to the topic. You should get the book, Healthism, Health Status Discrimination in the Law. It's not really, it really starts to get at the base foundational questions of how do you define these issues, but it's not really a book for lawyers or for scholars. It's really written in a way that I think anybody can understand it and start thinking about some of these issues. So we'll put a link to the book where people can get a copy of it. And want to say thank you, Elizabeth Weeks, Bulldog law professor from the University of Georgia and the co-author of this book along with Jessica Roberts. Thank you so much for being on Good Law, Bad Law.
Thank you so much, Aaron. It was a pleasure.